bafulayo wadde peke yeddagala nendeeta eryanga awaka ne bagamba kampe ku mwana wange awo n'obulwadde ne baŋŋamba tekikkirizibwa. Kakati awo nfunira wange omwana wange anfuddeko lwaki tebamukkiriza ne bagenda ne bamujjanjaba. Munnayuganda talina gy'agenda kulaga mbeera wali Mmengo agenda kuddukirawa bamukkiriza bagende babajjanjabe babavunaane nga babajjanjabye naye kakati bali wano balwadde tebabajjanjabye lwaki tebabakkiriza ne babajjanjaba. Pulezidenti Museveni kkiriza abaana baffe bagende babajjanjabe. Embeera gye balimu si nnungi. Omwana wange ajja kufa namufuna mbugubi obuyitirivu okufuna omwana wange oyo naye naamala afaako bannaye simanyi kyegenda nakukola bannange simanyi kyegenda kukola mbabuulira n'omwana wange bannange simanyi bannange simanyi kyegenda kukola ng'omwana wange oyo angezeeko ye mwana wange gundasookerako gwegubiddeko bannange naye twabeera bulago baba ne mujama sira mu kigere ng'akozesa bunnyo bannange lwaki tebamukkiriza ne babajjanjaba bonnaye
Maama, better strong. Freedom is coming. Freedom is coming anytime. We shouldn't worry. Bana mukisa gwa baloya sigwange. Mukisa gwa council.
Therefore, request for time that we get time and come up with a ruling that will cover all the matters we have raised. So we adjourn this matter for a ruling to be delivered on the 29th of June 2022. That is Wednesday next week. That should be heard immediately. You are ready to proceed. Because it's not a joking matter, it's not a laughing matter. This is a serious issue. People have been in prison for 9 months. They were released on bail at one time, then were rearrested. Charges are grave, treason and murder and so on. There should be a trial. They are members of parliament. Now their constituencies are not represented. You see the effect of delay. And you now come here with the technicalities. You read the law very carefully and you're using technicalities to make sure that they remain in prison. But the trial should be there. That's the only way justice can be attained. Okay, you're finished. I'm sure you have had. Mr. Wakafu?
Maybe this point that the bail is an intellectual proceeding. In my opinion, it's not an intellectual proceeding because the substantive proceeding on its own, because it's a proceeding which is meant to preserve a right pending trial, the right to liberty pending trial. The law is recognized in our constitution. My colleagues are quoting the sector of Shabas Attorney General, which is embedded in the 1967 Constitution. That Constitution, my lord, is very different from the current Constitution we have. The current Constitution clearly spells out bail as the right, and the right to liberty under what circumstances can be lost and so forth.
Yes, so to clarify, you know you are now talking and the press are watching.
Yes, my lord.
The right is to apply.
The right is to
But
apply.
not to grant. The right is to apply for bail under the Constitution.
Yes, my lord.
But it is not to grant. The granting is at the discretion of court.
My lord, that is not true. The discretion of court was spelled out in Article 22, Clause 5 of the 1967 Constitution. The current Constitution doesn't say so. You must give valid reasons for refusing a person bail.
That's what it is.
Yes, the bail can be refused, yes, but the court under Article 22 is supposed to enforce the person's liberty, but the good grounds bail can be rejected, can be refused. So, my lords, the problem we are having today is that we lived so long with one constitution for many years, and this new constitution we still keep doing the jurisprudence of the past to today. So, my lords, bail is a right under 23, and Article 50 of the Constitution empowers the competent court to enforce that right. So the competent court in this case was the High Court. Yes, my lord.
Today, what the Constitution says that a plea is not grounded in law. There is no law that allows you to appeal. A refusal.
My lord,
Where did you answer that?
I'm answering it, my lord. Under Article 50 of the Constitution, the right to liberty is one of those. No, it's one of those rights which are guaranteed in the Constitution, supposed to be enforced under Article 50. Article 50 says these rights shall be enforced under the competent court. And the competent court in this case was the High Court, but under the Human Rights Enforcement Act of 2019, Section 16, it states that there is a right of appeal when any of those rights under the Enforcement Act. I'm sorry, but
Because of section of the Human Rights.
proceed. And I'm sure the case of Makombi was decided before the Human Rights Enforcement Act was enacted in 2019. So the High Court made an error in refusing to release the accused persons on bail. Officially, my lords, the accused persons have been granted bail by an earlier court. Now, when this matter goes to another justice, the justice did not take into account the fact that these people have been on bail, and therefore did not interrogate why they're coming back to the same court for bail. Failure to interrogate that matter led to an injustice, my lords. Because first of all, the judge of Koiko jurisdiction cannot stand on appeal. Cannot stand in appeal to a decision of his or her brother. So in this case, the Ssegirinya was supposed to enforce the decision of Justice Iva. No. My lord,
They didn't have to arrest him.
my lord, they were not arrested, my lord. They were actually kidnapped. I don't know if a better word than kidnap, abduction actually. Actually, they were abducted.
Okay.
All jurisdiction, yes, particular jurisdiction, are not overturned in the decision of another judge. And at the same time, you brought in some facts saying she ought to have interrogated the fact. But I want to know exactly, are you dealing with the question of jurisdiction of this judge who refused to pay? What are you dealing with?
My lords, he was supposed to do so, to enforce their rights and ask himself why are these people back when they were granted bail. They didn't have explained what exactly happened. My lords, the affidavits in support of their bail before Justice Ssegirinya, they clearly showed that they had been abducted and taken back to the same court. My lords, this court, this matter of the black number, my lord, it happened when the security forces forcefully entered and scattered the right of court to grant bail at one time, and then it was termed as a discretion of the Court of Justice. My lord, this time they did it in a very clever. They went to the prison instead of having them killed.
Okay, Mr. Wakafuzi, that is now, you're not going into areas which are not in issue.
My lord,
The Black Mamba and so on, we have no facts of that in the chorus, and we are going into all matters like that.
my lord, before you,
Yes.
I'm sure on the proceedings before you, you find a ruling of one justice having released those people on bail. Why were they getting taken back to another court?
Yes, and I'm asking.
And what circumstances?
Is there a question of jurisdiction? What you are saying, no, we have jurisdiction. So we could.
In addition to the submission made by my colleague Abdul, to state that this court is seized.
Is he more serious than you? Is he more serious than you?
Yes, my lord, is my senior.
You see that him though is a salon.
My senior.
Okay, proceed.
My submission, my lord, is that this court is seized in the jurisdiction that of this act. And I'll demonstrate. Constitution creates that right. That is clause 2. An appeal shall lie to the Court of Appeal for such decisions of the High Court as may be prescribed by law. So that is the starting point. Where there are decisions made by the High Court, an appeal shall lie. Now, what does the law say? The law prescribes the procedure on how that appeal shall be preferred. I'll take you now, my lord, to the Criminal Procedure Code Act, Cap 116, particularly section 36. My lord, you look at two provisions, 35 and 36, to make an informed decision on this matter. 35 is about appeal against an acquittal or dismissal. That is 35. That's when the matter has been heard on merit and the decision is taken either to acquit or convict an accused person. But 2, and this is where our case lies, Section 36 provides that power of the appellate court on appeals from other orders. And this is what it says. The appellate court may, on any appeal from any order other than a conviction, acquittal, or dismissal, alter or reverse the order. This, in effect, means appeals lie before this honorable court from other orders or decisions other than acquittal or dismissal. So the jurisdiction of this honorable court is not restricted to all the acquittals or dismissals.
Does it be such a way that when we are dealing with an appeal under section 35, you can also deal with any order, other orders, which are in way of whatever. And this is the latest statute, and earlier statute. When you look at the trial and the latest statute, section 1, which seems to be
My
where there is two statutes, what do you do?
36 of the Criminal Procedure Code.
You have done very well.
Now I'm proceeding to the TIA.
Yes.
He read only section 132, but he not address you on section 133, which also falls under the same chapter. 133 of the TIA. Yes, the 12 Enactment Act. 134, 33 rather. Which also falls under the same chapter on appeals against High Court, appeals before this honorable court. And now it says appeal against special finding. a person in whose case a special finding has been made may appeal against the finding to the Court of Appeal on a question of law or fact, or mixed law and fact. And the Court of Appeal shall allow the appeal if it thinks that the special finding should be set aside on the ground that it is unreasonable or cannot be supported having regard to the evidence, or that it should be set aside on the ground of a wrong decision on any question of law if the decision has in fact caused a miscarriage of justice, or on any other ground if the court is satisfied that there has been a miscarriage of justice, and in any other case shall dismiss the appeal. But the Court of Appeal shall, notwithstanding that it is of the opinion that the point raised in the appeal might be decided in favor of the appellant, dismiss the appeal if it considers not substantial miscarriage of justice has actually occurred. And we are saying
What is the special finding?
the peculiarity of the bail proceedings, which was the case was made by my lad friend. It's not an interlocutory matter. That's the point I'm substantiating. That the proceedings in regard to bail, especially in nature for enforcement of rights, it's a creation or a creature of the Constitution, that the right to apply for bail, and the original proceedings, the right to apply for bail are separate proceedings. And these proceedings are initiated under Article 23 of the Constitution, and the court has a discretion to make a decision. Now, when court has in making a discretion or renders a decision with material irregularity, then this honorable court has all the power to intervene. A decision on bail cannot be taken to be interlocutory in nature. That is one. Two, it will be an absurdity for one to contend that a decision on bail at high court level is final. It's an absurdity, my lord. And say the remedy lies in filing a fresh application. Suppose I file incessant applications and they are all dismissed, like it's the case with this matter. You file, you go back before the same judge, again he dismisses on the same grounds. Like in this particular case, the judge said, your special status as members of parliament clearly indicates that you are flightless. You can always run away from this jurisdiction. How is he going to change his mind if we appear before him again? Because the file still will go before High Court. So with that curtail the jurisdiction of this honorable court, we are saying no, an appellate court can interfere in that matter. And again, my lord, to further buttress that particular argument, I take you to Rule 2 of your rules of procedure, the rules of this honorable court. And that Rule 2, my lord, is wide in nature. The applications were adamant.
Let's first deal with the people. We shall get to that if we...
Most of that, my lord.
And in a situation where you are moving up to the high court and not getting what you want to say. Now, your colleagues are thinking about enforcement of the right. And actually, sorry to bring it out, but when you are dealing with enforcement of fundamental rights and freedoms, you know, in the ordinary course of the trial, you apply for bail. But there are special proceedings for enforcement of fundamental rights and freedoms. Is it possible to take those proceedings under the title of enforcement of fundamental rights and argue those points before the High Court?
My lords,
maybe under Article 5 of the Constitution, as they are saying, you move under that.
my lords, when a person has been charged, brought before court, charged before court, and is entirely in the hands of the court, again, you can commence other proceedings when court has got power. They will tell you, the same court will tell you, you have a remedy which is prescribed under the law. to apply for bail.
Applying for bail, you say is separate.
Yeah, this is what I'm saying. But you have a remedy which is provided.
Listen, my brother says, can you go through the human rights enforcement procedure? And you are saying you cannot start free proceedings when a matter is in court.
No, when
they
they
have also argued that bail is a separate procedure.
We have no control over expeditious filing because sessions are arranged by court according to the available funds, which is beyond us, even if it's beyond court. Sometimes the Ministry of Finance are not releasing money, it's a new budget. So these things delay trials.
Yes, we all know that. That those circumstances.
Second charge being,
What charge is that?
it is murder and terrorism. The second one is Luengo, CRB 203 of 2021. Your Lordships, those two charges are totally different, separate. The parties are different, same for the two applicants who appear in both files. But the parties are different. Yes, the accused persons are different, and the places of commission are different. Luengo CRB was committed from within Luengo district, whereas Masaka CRB 605 was committed from within the from within Masaka district. Your Lordships, there is, whereas the applicants are not. Your Lordships, the second one is murder, one count of murder.
No, the first one is murder and terrorism.
Yes, Your Lordship.
Then the one of Luengo is what?
Murder, one count of murder. On the first count, in Masaka 605, there is murder, terrorism, and attempted murder. And Your Lordships, one of the challenges we are facing is the multiplicity of cases. This matter, this issue of duplicity is before the Constitutional Court. However, in as much as the parties, the applicants are not the parties in court, but the subject matter is the same. Your Lordships, about a week ago, we were at the War Crimes Division of the High Court in Kololo, arguing and opposing an application by the same applicant.
You are going too far into that. This is the rejoinder, please.
Much obliged, Your Lordship. Your Lordship, it is not true that Justice Toyanze exercised his discretion with material irregularity. He exercised his discretion normally, and the applicants.
They say judiciously.
Judiciously.
Yes.
Much obliged. And the applicants have omitted deliberately to pursue the remedy that is available to them. Where they have filed an application or applications, and the same is not being entertained, Your Lordships, they have a remedy under the Human Rights Enforcement Act.
Also, something for your very extensive submissions and the authorities you have quoted. You are raising matters that need to be looked into much more closely than meets the eye. We therefore request for time, that we get time and come up with a ruling that will cover all the matters you have raised. So we adjourn this matter for a ruling to be delivered on the 29th of June 2022. That is Wednesday next week. This is the Court of Appeal of Uganda. If you want to go there, you go there. We are going to be here. These people are in prison.
My prayer is only one. Those people need treatment.
They need what?
medical treatment. Can they be out till 29th?
Out of bed.
This is the bail application is what we are going to hear. So how do we again circumvent that? Let's handle first things first. Yes, I see the hands of both Ssegirinya and Sewanyana, Honorable Ssegirinya. Can we start with the Honorable Sewanyana?
First of all, I apologize for leaving court without applying to you. I wasn't feeling well. I thought that I could go out and vomit a bit. Your lordships,
Sorry for
we are very sick here in the Chico prison. We have complained about it for several times. It is now 9 months complaining about the same. Lower courts and other courts ordered for us to be given a priority of having special medical attention. Up to now, I have not yet got it. The lordships, we have children to look after. We have constituencies to look after to represent in Parliament. We have projects that have stalled for more than 9 months now, that are waiting for justice there. And through you, your lordships, if you could help us and grant us a leeway and leave prison, get a temporary freedom for all that, to enable us against treatment, at least reach that day when the trial will commence, when we are faced with attending trial, the lordship. We were tortured when we are arrested. We have complained about this for several times, but as the state has denied it several times. But we know that in front of you, we can get that justice that we came for. I so pray, my lordships.
Thank you.
It's quite absurd that the state is using remand as a punishment, and it's in the Rwandan Constitution that remand should not be used as a punishment. Mumaziga, I was kidnapped at the entrance of Chico prison the day I was released. I was tortured, but after today I never received any medication. Well, our reply is that this is just for today, so that we can go and get better medication. Thank you. That's my prayer, my words.
Both of you, we are sorry if you were tortured. Torture is not allowed in this country. It's outlawed. It's a serious matter, and the court takes it seriously too. So if anybody tortures, it's against the law, and the court cannot allow that. For treatment, the court law had ordered that you be afforded treatment in a place which fits your ailment. And we reiterate that the prison authorities should, where you are ailing, should give you appropriate treatment. The application before us is for bail. So we are going to hear the application if we allow this, if we don't allow this preliminary objection. There's an objection raised that this application should not be heard by this court. And that's what we have been hearing since morning. We are going to determine that and see whether the bail application is heard or not. And depending on the result of this preliminary objection, we then decide how to handle the matter. So the matters you raised, both of you, regarding your constituencies, your children, your sicknesses, and so on, if the bail application is allowed to be heard, will be addressed in the hearing of that application.
Maybe a question. Can you be clear? Are you saying that the treatment you're getting in hospital in prison is not sufficient? Because we are aware that the prison provides, specialists who visit and they assist you. You are not specific. Because the court is like he said, the court is not adverse to you being in good health. Did you hear what I said?
Yes. Yeah, but we have always complained about it, your lordships. We have ailments that cannot be handled within the prisons, heart attack, and others of hypertension, and others that we suffered when mishandled at the day when we are rearrested. Some of our private parts are not well. We believe that if given that chance and go out, we can have our lives made better by special physiologists, and we will thank God for that. That's what we are meaning. But for malaria, there is treatment, and cough, there is treatment, but those are not the sicknesses that we are talking about. We are talking about ailments that need special attention, as you will hear if you grant us that chance of hearing our babe. You will hear from the presentation of our lawyers and us on that day. I thank you, my lordships.
Yes, you raised an important issue of ailments touching on your private parts and so on and so on. Did I hear you well?
Yeah.
Sewanyana, did I hear you well?
Yes, you heard me well, your lordship. Only that the internet is disturbing us a bit.
Because then which facility in Uganda do you want to go to handle that? Are you saying you should, because you have not mentioned that we should be taken to Mulago, because Mulago is the referral hospital in this country? Should the prison authorities take you to Mulago for treatment or something like that?
We have always tried for such, but they have not, my lordship.
Okay, we note that, and we are asking and directing the prison authorities to ensure that you get treatment which will be able to handle your ailments in this country. Do you have a prison officer? In the
I'm number 15722, Warder Ronald, working with the Ghana Prison Service, specifically at Chigo Main Prison. My lord, as far as the medical issue is concerned, our medical team is handling it very well, and I am convinced in case they need to be referred to the National Referral Hospital, which is Mulago, our medical team can easily do that, my lord.
Is it being done? The question is it being done?
The condition is not bad, my lord.
No, the protested that, my lord, is not competent.
It is a statement, he's not a doctor.
Yeah.
He's just saying they are being looked after and they are getting medical attention. Now, what is saying he needs a specialized.
Yes.
And we are asking the prison authorities that please ensure that they get appropriate medical attention, including if it is necessary to take them to a specialist or to Mulago Hospital where we have all these specialists.
Okay. Much of my lord, we are going to ensure that that directive is handled, is taken into consideration, my lord.
For the record, my lord, almost of them.
He's sick, he's near you there. And he says he's not feeling well. And he has just gone out to vomit and come back. I'm sure you saw that, you must have followed him. So the ailment is there. I think it is important that we set timelines how you have these people treated by people competent to treat their ailments. Can we then say that maybe every 7 days you call a specialist, and if they are not able to come, you take them to a specialist. All the specialists are in Mulago Hospital. Either you bring them to the prison, or you take them there and they get that attention. Before we come back here, we are going to be here next Wednesday. So they should be treated before that date.
specialists should know whether they need referral or not.
Okay? Is it clear? Prison officer, is it clear? Have you heard?
My lord, you're not clear. The mind of God is not so clear, my lord.
But you have heard that we want them to be taken, or a specialist to see them before we come back here next Wednesday. The medical
Okay,
people have
thank you so much, my lord. We are going to communicate with specialists, my lord.
Council areas, do you have anything we think you don't have any right to reply?
No, it's not any reply, my lord.
Yes.
Because in regard to that issue,
Yes.
my lord, there are previous orders that have been given, but they have always been deferred. That they be taken from examination. And not calling in the physician, because the physician will not come with the equipment. Say, for example, they need a scan or MRI, whatever.
That will be decided by the doctors. They know what is needed and where it should be done.
Most of that.
And those orders were not given by the Court of Appeal. These are orders of this court.
Most of that, my lord. Just for the record, my lord.
Okay.
Just my personal one. That on that different
Okay,
night.
thank you.
Yes. On 29th, I'm not here, but my colleagues.
That is another matter. We have not reached
Okay.
there. Don't cross. We have finished. The court has finished that matter. And so,
Just inform me before.
if that day you are not here, whoever will be representing them will so.
I just wanted to be on record that I'll be out of the country, my lord.
No, we can't put that on record. Because that file is closed anyway.
Most of that. My colleagues will be here.
Yeah.
Most of that.
Okay.
Yeah.